The rise of the 20th century phenomenon of no-fault divorce should not be surprising in light of the preceding discussion, right? I've laid it out. That's how it took place. No-fault divorce has been described as divorce where no fault, responsibility, or offense is attributed by the law to either spouse. When marriage is no longer even viewed as a contract in the true sense of the word, right? I agree to do something and you agree to do something, then it logically follows that either party can opt out of the marriage for basically any reason. Authentic contract principles, at least, would dictate that a unilateral default by one party is not justified unless there's a material breach by the other. Now that this concept relative to marriage has been largely discarded, there is no standard left for the courts to say what is and what isn't a valid reason to sever a marriage. No-fault divorce is the fruit of a number of factors, among them the abandonment of contract principles relative to divorce. Courts still do, and people still today, refer to marriage as a contract, but their use of that word is confusing. It has been emptied of its traditional meaning. Attached to no-fault divorce is the notion that marriage is not something that occurs as a result of countless choices made by the parties to ensure a certain good. Instead of responsibility, or fault even, we have no fault. Therefore, whether or not one is married is essentially a matter of chance, and therefore, fault cannot be apportioned to parties. Consequently, everything that follows is natural. The costs of divorce are to be shared by all members of society, right? Whether you're married or not, since it's not your fault, you shouldn't have to pay for it. You might pay for it directly in certain ways, but we pay for the courts. We pay for all the social breakdown. We pay for all of it. They're shared by all members of society. In short, modern no-fault divorce forces married persons to be taxed to handle the consequence of divorce. No-fault occurred officially in California in 1969. However, there were already many unofficial no-fault divorces before California began the official practice. It wasn't new, essentially, in California because they had already begun what were known as Omnibus Clauses when people were seeking a divorce. And that is, what they would do is they would just say in the legislation, they would give courts broad discretion for determining what were grounds for divorce or not. So you kind of had these, whatever the judge thinks is enough is going to be enough. And so as a consequence of that, no fault was sort of the easy way into it. This legislation, as everybody knows, common knowledge, it appeared in 1969. And the California legislature at that time, fearful of causing the divorce rate to increase more, didn't actually enact pure no fault at first. The legislature's best intentions would have little effect, though. The law passed in 1969 sought a compromise between no fault principles and the maintenance of judicial control and discretion. In practice, however, it appears that the judiciary interpreted these terms as liberally as they had earlier treated the term cruelty. As the history of divorce has shown, once the door is open to increase or expand the grounds for divorce, it is virtually impossible to control the results. No-fault divorce was first introduced in California in 1969. By 1985, with the adoption of no-fault even by North Dakota, all 50 states had adopted some form of no-fault. In addition, as the courts were acting, or as the legislature were acting, the Supreme Court actually got into the act too. So my part of the world, the judiciary, the lawyers. And in a very famous case called Zablocki versus Redhale, the Supreme Court decided that a party had a fundamental right to marry. A fundamental right to marry as many times as they wanted. In Zablocki versus Redhale, there was really a great piece of legislation in the state of Minnesota where the law said that if you were divorced, you were not going to be granted a marriage license unless you could prove that you had the ability to care for the children and spouse of the previous marriage. So you weren't going to get another marriage license unless you could show that you knew how to handle what you'd already gotten yourself into. The Supreme Court rejected this position, and subjected this law to what's known as strict scrutiny, which means it never passes the court's standards. And as a consequence of Zablocki and all of this legislation, there was no control anymore over limiting divorce. You should realize then that what we end up with is no-fault divorce. And what have we experienced as a consequence? We all pay for these battles. Divorce cases constitute a huge portion of the civil docket in every state in the Union. Let me give you a few examples. One study shows that domestic relation cases in 5 different counties in California rose from 21% of filings in 1903-1904 to 49% in 1976 and 77. I don't have anything later. That study wasn't done. I'm sure it's higher today. In Alameda County, they went from 18% in 1890 to 51% in 1970. In San Bernardino County, from 19% to 61%. A 1976 study done at the general jurisdiction courts of 8 states found that in all but one, state domestic relations made up more than 50% of the total civil caseload. This percentage bears repeating. Over 50% of the total caseload are domestic relations cases. Divorce proceedings are typically composed of both status and non-status disputes. Status dispute relate to the actual severing of the marriage bond, while non-status disputes relate to such things as alimony, child custody, etc. The child custody ones and the child custody issues can be in the courts for years. Both of these cases take up a considerable amount of time, and some of the studies out there show that essentially, more or less, that the divorce in the United States costs $33 billion annually, or approximately, and this is the cost we pay, in other words, the taxpayer, not the people who are involved in divorce who have huge costs themselves, but it costs the average American about $350 a year to pay for all the divorces directly, not indirectly, in the United States. They figure each divorce costs more or less for the state about $30,000. Moreover, the divorce epidemic in the United States has created a divorce caste. Within 30 years, since 1969, America has witnessed the creation of a class of families where divorce occurs in every generation. This is because a couple's divorce roughly doubles the odds that their adult children will divorce. Studies show that the odds that a couple will divorce increase by 189% if both spouses come from divorced families. Children have also been hurt. The collapse of marriage is the principal cause of child poverty in the United States. Children raised by never married mothers are 7 times more likely to live in poverty than children raised by their biological parents in intact marriages. Overall, approximately 80% of long-term child poverty in the United States occurs among children from broken or never formed families. The governments obviously bear the cost, huge amounts of cost. And it gets back, I want to get back now to sort of my conclusion here, or near to my conclusion. No fault is a horrible pox upon our society, and every marriage in America, no matter how religious, no matter how serious the parties took it at the time they got married, is considered a no-fault marriage. The consequence of these, Bay herself has told you about. I've observed them. What happens? Judges control your life. Psychologists control your life. Your children are left to drift. They're left to be cut in half. A parent who is not at fault is treated the same as a parent who is at fault. Is there a way out of this? Is there a way out of this? I think that there is a way out. Among the ways out, all 3 of these ways are ones that I'm currently working on. Number 1, all people who enter into marriage need to enter into some type of prenuptial agreements. And Catholics, I think, have a natural reaction of negativity against this. But they need to enter into these prenuptial covenants, call them whatever you want, that ensures that their marriage, to the degree possible, will be managed by people, by the church, or by lawyers who act as arbitrators or mediators who share the values of the Catholic couple. Okay? That's the number one thing that they should do. Everyone should enter into it. The prenuptials have been more and more increasingly recognized. And the beauty about the prenuptials that I recommend is that since they do not guarantee a property outcome, they're even more likely to be upheld by the courts. Because all they do is say you have to go through an alternative procedure. Okay? The alternative procedure being a procedure in conformity with the teachings of the Catholic Church or the religious beliefs of any party that enters into it. Secondly, we need to try to defend all marriages that have been taken place in Catholic churches, because truly, people who enter into such marriages intend the marriage to be permanent. As Faye pointed out, she didn't intend a no-fault marriage. They came to the Catholic Church because they didn't want a Vegas marriage. They could have gone to Vegas and got a Vegas marriage. Instead, they wanted a marriage that was in conformity with the marriage of the Catholic Church, and that's why they sought that particular tribunal. We are going to defend this case all the way up till the courts stop hearing it. If we lose, we're going to take it all the way, and we're going to take more cases like that. Thirdly, we need to draft legislation that explicitly protects those types of agreements and religious marriages. And that's sort of the tripod of ways in which I think that we can help to end the curse of no fault on American society. Thank you for coming, and if you have any questions, I'd be happy to take them.